Well, happy whatever day this is that you're joining us. This is Richard Rosen, Winnipeg's friendliest undertaker, and my recording engineer, George, who's joining us here today. And the purpose of all of our interviews has been to share knowledge on a wide variety of topics. So if you've been watching our interviews over the last number of years, you'll know that we've been covering a wide variety of various funeral topics, including green burials, the importance of managing and protecting your digital assets. And recently we've launched this new segment on successfully aging in place. Now that I'm into my 50s, later 50s, the topic of aging in place has really become a new part of my life. And I really need to be aware of and to learn how to successfully live and safely live so I can continue to enjoy the best quality of life that I possibly can. Helping with that success really became part of my journey. And what I did was became an early member of businesses and organizations supporting seniors, people working in the aging in place community, helping to create and maintain the best quality of life possible for older adults. So if you're looking for a good audiologist, a financial planner, additional home care, a pharmacist, or a lawyer, to name a few, you can go to my website where you'll find a page dedicated exclusively to BOSS, and it has a list of the members that are there and links to all of them. And you can also take a look at the BOSS Facebook page. Speaking of lawyers, we welcome today Andrew Torbiak with Tradition Law LLP Estates and Trusts here in Winnipeg. While his practice is estate law, he focuses on estate planning and provides consultation to clients related to committeeship and attorneyship issues, as well as estate beneficiaries. Andrew was called to the Manitoba Bar in 2016 and now gives back to law education as a sessional instructor, coaching third-year law students at the Canadian National Negotiation Competition. Andrew contributes to the Winnipeg community by sitting on the St. James Assiniboia 55 Plus Center Board. And he's volunteered since 2016 as a presenter through Senior Care Without Walls, a senior engagement resource offered by A&O Support Services for Older Adults. And additionally, and finally, Andrew, like us, are a proud member of businesses and organizations supporting seniors. Andrew, thank you for joining us today, and looking forward to a good conversation about things that we need to know about our estates and those plans.
Well, thank you very much for having me, Richard, and of course, George. And it's my pleasure to join you. I'm always happy to chat about these topics in general, and then more specific to me, legal topics, which for the most part, a lot of folks don't have the perfect handle on just yet. You have more pressing, immediate chores that you could be dealing with. And it's, at least in North America, you could probably advise me better. I find that we don't often think about the issue of passing away and what should happen after we're gone, maybe as healthily, maybe as much as we should.
Well, you're absolutely right. I mean, it is quite a challenge. Not even less than half of Canadians have a will, and that quarter of that half is how updated are they? We've got grandchildren that are new and family dynamics that change, and who keeps up with that sort of stuff?
You're absolutely right. In my experience, there's sort of at the best of times, there's three main phases that folks might make a will. It'd be probably after they're, say, married and they have young kids. It might be about 20 to 25 years after that, where their kids are grown up. And then the third time will be when the grandchildren are coming of age, or at least the family picture is more or less solidified. So that's 3 kicks of the can. That's if it's being done, that's better than average that I'm used to coming across. I would just settle for 1 per person at the very least, because the other thing is, I don't know that people are very aware of the fact that the government has already written you a will. It's a piece of legislation, and it says, well, if you don't have a will, here's who gets what, and here's who's in charge. And sometimes that arrangement works out, but many other times it doesn't. And unfortunately, you do come to see a lot of issues surrounding that particular piece of legislation when you do what I do and you work in this area.
Right. Yeah. I guess, the from my understanding is that there's really, I think most people understand that there's two things that you're doing, two primary purposes for writing the will. And one of them is to really name the executor. And then the other would be to divide your assets including your financial wealth, assets including golf clubs and dishes and things, and digital assets, which of course we'll get into too. So you're dividing this stuff amongst the beneficiaries, but that's really not, is that the whole story? Or is there other things that you would think would be valuable when creating a will?
That's a very good question. And you're absolutely right. The first two things that people that comes to mind or that people think about when it comes to a will is who's in charge. So that's your executor. And then who am I actually giving to? That's your beneficiaries. If you've at least gone that far to set that down in a will, I'd say you've probably covered off 3/4 to 90% of the important business, let's say. There are certain situations that could be helped, however, by going a couple steps further. And these are simple steps, like these aren't elaborate, costly, difficult steps to take. It's simply to have them in mind and to consider other things than just, that bread and butter executor beneficiary decision making. So one example would be, as you alluded to, just simple possessions. So physical things, stuff that isn't as easy to separate, in a percentage. So let's say you have 3 children and you've divided your estate evenly between those 3 children. Well, how do you divide a piece of art 3 ways evenly? Is there going to be some kind of custody share? Not likely, or if there is, it's probably not going to work out. And so one added, I guess I'll say, benefit or trick even that I'll often put into wills is reference to what we call a memorandum of distribution, fancy legal term for a list of personal belongings. And in that list, you can specify who you want to get, the piece of art, war medals, guns, antiques, jewelry, sentimental items. The beauty of the list is if it's not strictly in the will, if it's simply referenced by the will, which is what that section would do, it would simply say, I'm writing a list somewhere else. And the beauty of that is you can change and update that list for your entire life. Every 2 years, you could sort of do an audit of your personal belongings, and you could check in with your family if that's something you felt comfortable to do. And you just update your list, and you don't need to call up or frankly pay a lawyer to do anything to your will. You just rewrite the list. Most folks would say, they don't want anything. I'm not worried about it. And I get that. But in the right scenario or the wrong scenario, we'll say, emotions and sentimentality and personal dynamics between the people who are left behind after you pass away can bubble up to the surface and manifest themselves in, jealousy or coveting or feeling of being slighted when it came to how personal belongings were decided, how they were distributed. There's a very famous case whose name I can't recall, but there were 2 siblings fighting over a pair of emerald earrings. We're talking about an estate worth millions and millions. It was all dealt with. It was all boiled down except for this pair of emerald earrings. and they were going to court over these earrings. They're paying lawyers, they're stalling things, they're dragging their family through a really difficult situation. And at the end of it all, the judge was very fed up. And the judge said, "Do you have the earrings here? Bring them to me. I'm keeping these. You have 1 week to come back to me and tell me what the arrangement is that you've reached for how these earrings are going to be dealt with." And they came back a week later and they didn't have anything better to tell the judge. So the judge said, "Okay, we're going to come back one more time. And the next time we come back, there will be a replica pair of earrings that the estate is going to pay for." And they came back again, and he took the replica in one hand and the pair in the other, and he put them both into a bag, and he went like this. And he said, "Pick one, pick one, pick one, pick one." And that's it. Now the issue is dealt with. So that's what you call a good legal result when everybody is equally unhappy. If mom or dad had simply written a list out and contemplated such an item and foresaw the issues that could arise surrounding that item and accounted for that item in other distributions of personal belongings, that estate would have saved thousands and thousands of dollars in legal fees. And well, we wouldn't be talking about them today, but all the same, it's quite a cautionary tale. So that's one area outside of executors and beneficiaries that you can really supplement your will with to help avoid fighting or strife in your family.
Yeah, I've learned it's sometimes the whole aspect of the estate can be really like kicking a beehive, because it will or it can prompt unresolved issues from a long time ago, where now it's all focused. It's the boiling point is hit because of a death, and now the estate needs to be dealt with, and everything is just as you said, if it's not dealt with properly, then how can that be mitigated? How can you do that without causing too much more grief and anxiety?
And if there has to be a bad guy in the situation, you should make it yourself. You should write the list and make the decisions, and they might disagree with it. They might not be happy about it, but at least they're not pointing the finger at their siblings. If they have to shake their fist at somebody, let it be at you, because you've passed away. You're no longer, you're not here to fight with. You put the fight on yourself, or the disagreement, I guess you could say, on yourself, so that it's not between, in that instance anyway, children. Apologies. To a hammer, everything looks like a nail. So sometimes the first thing that comes to my mind is what dispute can arise. The other thing we should consider is it's hard enough to be an executor. If the executor is a loved one, they're already going through a difficult time from the loss of, the person who wrote the will. And so if you can write a list or take steps that also remove uncertainty from the mind of the executor, who's just trying to do their best and trying to properly, act out what your wishes might have been. And now there's anxiety and there's second guessing, and am I doing the right thing? Should I donate these things? Should I just hang on to them? Who should they go to? If you can take all of those decisions, that burden, off of the executor, it's almost like another gift that you're making in your will. Even if you think the items that you are making decisions over aren't really all that important, you never know. You never know what they might mean to somebody after you're gone, because in a period of heightened emotion, like you say, feelings come to the surface. So just take that load off of them.
Thank you, Andrew. We're really grateful for your insights and sharing all of your knowledge with us here today. And to our audience, we're grateful for the time that you've invested with us here, and hope that we've offered some new insights into the area of aging in place that might have been new to you. And if you like this interview, please hit the thumbs up button on the YouTube page, and also don't forget to subscribe. This is Richard Rosen, Winnipeg's friendliest undertaker, signing off. Keep safe and keep smiling.